Ampara for the kind introduction, and once again the Center for Postgraduate Legal Studies and Professors Patnaik and Gupta for hosting me at Jindal Global University. It's been an amazing, wonderful 1 month that I could join at this university and stay at this university, interact with you, with students, faculty on the campus and also a bit beyond the campus. So I'm very grateful for that opportunity. So this afternoon I would like to present an argument on the authority of international investment tribunals and ask the question in whose name they decide, in whose name they speak the law. And as James suggested, please do feel free to ask questions. In the meantime, the presentation or the interaction then would be about half an hour, so then James would have an opportunity to comment, and I look forward to further questions and discussions in the wake of the presentation as well, but do feel free to ask questions. Now, I would like to lead into this topic, this theme, in whose name, on the authority of international investment tribunals, in light of a concrete example. And that example is one of the first case of investor-state arbitration that was filed against India, which you might be well aware of, which is White Industries against Australia, and it serves now as an illustration of the structure of this way of settling the disputes. Now, White Industries is an Australian company that had entered into a private contract, with Coal India, also a private actor, about the possibilities and activities of certain mining. And sure enough, a dispute arose between them, so they went to commercial arbitration, the International Chamber of Commerce, where an award was rendered in favor of White Industries. Now, what does it have to do with investor-state arbitration, with an international arbitral tribunal? Now, White Industries tries to enforce the award in Indian courts. And the Indian courts don't readily cooperate, or let's say they drag their feet a bit. So White Industries, trying to enforce the International Commercial Arbitration, ICC, award in Indian courts, sees that Indian courts do not live up to their task of enforcing that award, and it brings a claim now against the state of India, against the host country, the state of India, and alleges breaches of a certain number of kinds, including expropriation, denial of justice, and also the fact that it is not given an effective remedy, an effective access to actually enforce its award. And how is that possible? How is it possible that this foreign investor, White Industries, now brings a claim in front of an international arbitral tribunal against a sovereign state, India? Now, the basis for this, as you might be well aware, is a bilateral treaty between India and Australia. So it's this bilateral investment treaty between Australia, the country of nationality of White Industries, and India, the host country. And this bilateral investment treaty defines the standards of protection, so the protection or the treatment that White Industries is due when it invests in India, and it also gives White Industries the possibility to bring the claim against India in the first place. Now, this possibility is a rather new phenomenon, a development maybe that exists for the past couple of decades. Now, before that, the world was one without such bilateral investment treaties or multilateral ones that serve those functions that I just described of providing a basis for the arbitration. So we lived in a world without such bilateral investment treaties. What does that look like? In that world, without BITs, international customary international law would have defined what actually amounts to a breach, and the only thing that White Industries could have done would be to try and lobby its government, lobby Australia, and try to push it or demand it, beg it maybe, that it espouse its claim, that it exercise diplomatic protection on its behalf. And for that to happen, the local remedies within India would have had to be exhausted. So what industries or Australia then would have had to show that no other remedies to vindicate its rights were available in India, within Indian courts. And Australia had complete discretion in choosing whether or not to espouse, to exercise diplomatic protection, espouse the claim on behalf of white industries. Now, in the world with BITs, that looks starkly different. So there we have the BITs which, in addition to customary international law, define the standards of protection. So they say what amounts to an international wrongful act. They typically do not require that local remedies must be exhausted, and they give white industries a right to directly itself bring the claim in front of the arbitral tribunal. So it's no longer dependent on the will of Australia. So how did we get from that world without BITs to the world with BITs? Now, the story of that development from a world without to a world with bilateral investment treaties is a quite intriguing one. It really takes off against the backdrop of failure. Well, failure of what? Of a multilateral agreement on the issue of regulating foreign direct investments. So in the context of the new international economic order, so with newly independent states pushing the agenda on economic issues in the late 60s, early 70s, including India among other protagonists in that regard, challenged positions that had been predominant until then and that had remained unchallenged, to the extent that there was no agreement on these issues any longer, and any multilateral attempt failed. And it was against the backdrop of that failure that two things happened. One, rather than multilateral, you started having bilateral agreements that defined these issues. And there was this smart guy called Aaron Broches, then Director General of the World Bank, who came up with the witty idea of, well, let's have the procedure for settling investment disputes, even if we can't agree on the law. Let's have the procedure so that the law would come along while adjudicating. So procedure before substance was his slogan. And that is pretty much what happened. So that, just to illustrate the development from the world without to the world with BITs, a couple of figures and trends in that regard. So you need the treaties and you need the adjudication practice. So the treaty development looks like this. So these are trends of international investment agreements. It's a more comprehensive term that includes bilateral investment treaties and other such treaties that have been concluded. And you see a really steep increase, at the end of the Cold War, peaking Washington Consensus and the idea of neoliberal legal ordering at the beginning of the 90s. So a lot of the agreements were assigned at that time. The first one actually was concluded by Germany in 1959. It has one of the highest number of BITs, about 130. Switzerland has many, the Netherlands have many, some countries have none, such as Brazil. India has about 84 such treaties.
But only 73 are actually in force.
73 are in force, all right, yeah. And more are coming. You have big negotiations going on at the moment with the US, and also just yesterday, or the day before yesterday, the new the model bilateral investment treaty of India was released to the public. So you can have a look at that. So this is the development of the treaties, and here you have the development of the cases that are decided over time, and you see that 90% of all cases that have ever been decided have been decided after 1990. So a very strong increase. Up to 1990, only 26 cases had been decided. And you see that every year after the year 2003, there's more cases than that have been decided every single year. Yeah. so a very steep increase. In ICSID cases, which International Center for the Settlement of Investment Disputes, it's one venue where such cases are decided. Another venue would be the Permanent Court of Arbitration administers proceedings that would be shaped by the rules of UNCITRAL, the UN Conference on Trade and Development. On trade. And this graph shows you the number of cases of not only ICSID cases but also other cases that are known to us. Some are also secret; they might never be notified. And here I also see the steep increase. And this steep increase has gone in hand. It's a development in quantity just as much as a development in quality, because when you move from rather sporadic one-off arbitral awards, one every other year or so, to one where you have about 50 and more per year, the dynamic of governance changes. So now you have a swelling stream of jurisprudence that shapes, that contributes to the making of the law in a way that is very different from a context where you only have one case every so often. I led into the theme with the example of white industries. Do you know other examples of investor-state arbitration, just to give you a bit more flavor, everyone a bit more flavor as to what kind of disputes we're talking about? Or you already know too many, so then...
Familiar with the Vodafone case?
With the Vodafone case, yeah.
Not a case actually, but there is a demand or notice.
All right. Yeah.
Against India.
Yes, exactly. Yeah, so there are so many, so maybe you already have too many on your mind. Just for more flavor, one which is as much a legal battle than a public relations battle, probably the public relations aspect overtaking the legal dispute, is the one between Chevron and its former subsidiary Texaco and Ecuador, disputes about oil spills in Ecuador. Another one, the champion of being a defendant in these cases is actually Argentina, that has to defend itself against a whole host of claims that have come up in the wake of the economic crisis ever since 2001. Recently, the Argentinian government decided to nationalize oil company YPF, and the mother company is Spanish, Repsol, and they decided to bring a claim against Argentina, and many more. Many more, including a case brought by Vattenfall, a Swedish energy company, against first Germany for environmental regulation in the city-state of Hamburg. And now also you might know that the German Chancellor Angela Merkel made a U-turn on the nuclear policy after the nuclear meltdown in Fukushima, and Vattenfall filed a claim saying that that amounts to expropriation of its investments in Germany in nuclear energy. So to say these awards matter in a number of ways. They matter because they touch on sensitive policy issues of pursuing public policy objectives, scope of regulation, regulatory autonomy. There in the jurisprudence you might argue there's a rather expansive definition of what amounts to an investment. There's a emphasis on legitimate expectations of the investors, and sure enough, those awards matter because they touch on these sensitive issue areas, but they also matter because they come with teeth in a way. So the awards can, this is an exceptional case, the one against Ecuador, also in favor of Occidental Petroleum, where $2.3 billion were awarded. That's not so common, but just to say the amounts that are being awarded for damages or compensation are significant. And those awards are globally enforceable in domestic courts. So all that to say, there's increasing cases and an increasing number of agreements. They matter, they come with clout, and then the question is, what justifies that authority? So in whose name do those investment tribunals decide? So many domestic courts say at the beginning of their judgment in whose name they decide. So it's in the name of the people, in the name of the prophet, of God, the republic, the king. And international courts and tribunals don't do that. So the question is, well, in whose name do they decide? And the main argument that I want to develop in the next 10, 15 maximum minutes is that international courts and tribunals, including investment tribunals, are multifunctional actors that exercise public authority and therefore require democratic legitimacy. So that also defines the program of the remaining time that we have, that I will shape with the presentation. The program being to first support the argument that they are multifunctional actors, to second show how they exercise public authority and what it means that they require democratic legitimation. And I do this against the background of a received understanding that looks at these arbitral tribunal and the practice of adjudication as nothing but an instrument in the hands of the disputing parties. So that is the common view and the well-received view that suggests that investor tribunals are instruments of dispute settlement in the concrete case in a state-centered, well, I should bracket that. They're dispute settlement, instruments of dispute settlement. And if that were so, they would be justified by the consent of the parties. You know, both parties to the arbitration agree, so we submit to this arbitration, and once the dispute is settled, we'll abide by it, you know, but their consent would carry all questions of legitimacy that there might be, or it would provide a sufficient basis of that practice in terms of normative legitimacy. And you have arbitral tribunals that embrace this view and that present themselves in precisely that light, such as the tribunal in a case of Romak versus Uzbekistan, where the tribunal said that its mission is to resolve the present dispute between the parties in a reasoned and persuasive manner, irrespective of the unintended consequences that this tribunal's analysis might have on future disputes. So we are authorized by the parties to decide the specific dispute. That's where it starts and that's where it ends, period.
What about the role of secrecy?
Good point. So it's of course not secret for the parties. And so they have full access to the submissions, to all kinds of evidence, to the pleadings, to the oral pleadings, and of course to the award. So if this whole thing was a bilateral affair between the parties, you might also suggest that maybe secrecy is not such a big problem. So in commercial arbitration, secrecy is more often than not the rule than the exception. And, well, if it only involves the two parties, maybe that's not such a big deal. But I, of course, think that the view is insufficient and implausible. Why? Because it eclipses other functions that those tribunals exercise. Yeah? So it eclipses other important judicial functions, and it underrates problems of legitimacy. Because it's not only about dispute settlement, it's not only about the concrete case. While adjudicating, investment tribunals stabilize normative expectations, so they say what the law is, and say that also for others, to the extent that the awards or the reasoning is published, even if the submissions or pleadings are not. Once the award becomes public, it amounts to, well, it's a statement of what the law is, and others will align their expectations about what the law is in that light. And it's also in that sense that the practice contributes to the making of the law. It contributes to shaping, to developing normative expectations at a further third function, and it reviews and legitimizes the authority of other institutions, domestic, administrative actors above all. And it's in that light that secrecy, so once you have the fuller view of what's happening, secrecy as a demand becomes less persuasive or less compelling. Especially, and that's one more twist to that question, if one of the parties is a state acting in sovereign rather than a private capacity, different from commercial arbitration, where the decision between, let's say, Vattenfall in Germany should probably not be secret if $40 million are awarded that have to come out of a public budget and have to be paid by tax money. So you don't have a private administrative decision or a secret administrative decision. Why should the arbitral tribunal be secret in that regard? And which is a big issue. In this case, actually, there was a settlement, and nobody really knows what happened. There are some informed opinions about what happened, but it's not public. So they are multifunctional actors. Yeah? They not only settle dispute, they do other things. And they exercise public authority. In the specific case, because they award financial, typically damages or compensation payments in the specific case, but also exercise beyond the case in the way that the decision reaches beyond the concrete case and affects lawmaking more generally. And shapes the law and thereby affects other participants in the international legal system. And my understanding of public authority here is one that certainly goes beyond means of coercion. That would be too narrow, because as every kid who has read a bit of Michel Foucault knows that power comes in many different forms, including institutional, including the checkbook, including structural and institutional. So with a broader understanding of appreciation of how power works and a broader understanding of authority that I wish to define as a capacity, so international public authority as a capacity that is based on international law to impact others in the exercise of their freedom, be it legally or only de facto. It is with this understanding that I think as a first step we can zoom in on the authority of those arbitral tribunals. And this conception of authority comes from a principled basis. So it's an idea that tries to capture those acts that impact on what public law is about. In my understanding, it would be about enabling and constraining public authority. Why? Because that's mechanism for allowing individual liberty and it is a vehicle for public self-determination. So any act that impacts on those principles should come within reach of that concept. And this here I'm connecting to research that is ongoing at the Max Planck Institute in Heidelberg on international public authority. So they exercise authority in the concrete case, but also beyond the case because of the working of earlier decisions as precedents. So mirroring the Saipem tribunal, you have others that present themselves as contributing to that development more directly, and they engage with and lean on earlier decisions, thereby contributing to the authority of those decisions. So one example being Saipem versus Bangladesh, where the tribunal found that it has a duty to adopt solutions established in a series of consistent cases. It has a duty to seek to contribute to the harmonious development of the law. And even if it didn't see that duty, so even Romak, which had a different self-understanding, was in a way, I would even say, disingenuous, because it relied heavily on earlier decisions. So when it came to the allocation of costs, it based its decision on costs exclusively on precedents, actually forgetting about the provisions in the ICSID Convention on that effect. Okay, so you have exercises of public authority because those tribunals have a capacity to establish their own reference points as inescapable reference point for later legal discourse. Yeah. So it brings me to a third and last step in developing the argument that international investment tribunals are multifunctional actors who exercise public authority and therefore now, third step, require democratic legitimacy. Now that's a very tricky issue. Well, what is the problem in the first place? The problem is that this authority, you've seen the development treaties and as well as arbitral practice has not gone hand in hand with politicization, with the development of a political legislative process. They would parallel, they would interact with that judicial process. And there are some other problems which I leave aside at the moment. And that's one, and the fact that I've stressed already quite a bit, that is, you have all these effects of adjudication beyond the concrete dispute, thus challenging the consensus of the parties as a sufficient basis. What then are pathways of legitimacy? How to contribute to the justification of that practice? I wish to focus on 3 avenues. The first one would be to connect to the men and women, mostly men, a couple of women here and there, who decide, who take those decisions. And I understand also in India at the moment you have a vibrant discussion about how to select judges, which forum is the right one to do so. And so I would push the question onto the international agenda. So who should select those men and women? What makes a good bench? How to nominate, how to select? What role of international fora to possibly select those men and women? A second avenue would be to connect to the judicial process and issues such as secrecy, transparency, publicness, possibilities of participation, possibly, amicus curiae briefs, possibly. Maybe, at the moment you do not have anything like an appeal possibility or a review mechanism in investment arbitration. You have something called the annulment procedures, right? Which could only step in if there's an excess of power or such things. So it's very high threshold, but it has actually developed sub silentio into something like a review in some cases, very slippery slope. So you have possibilities of reacting to problems in the justification of the public authority with regard to the judicial process. And the last avenue would be the judicial decision. And maybe just a couple of points with regard to the judicial decision. So third point, the judicial decision. So you have, how do you make sense of, or how can you approach judicial reasoning and judicial decision as a site where to contribute to the justification of the public authority that is being exercised? Well, you can, for instance, ask what the scope of reasons should be that the adjudicators should be allowed to use. So those of you a bit more familiar with the practice might have heard another big dispute that is still ongoing, Abaclat versus Argentina, where a first decision on jurisdiction admissibility held it would have been unfair to require that the investor first submit their claim to domestic courts for 18 months of a cool-off period. And you might wonder, as the dissent, there was a very strong dissent in the case by Georges Abissab, a prominent international lawyer, who said, well, is that for you to choose? Is that the right arguments? You shouldn't use that argument. And he actually made a separation of powers argument and said, well, the question of what is fair and unfair is not for the arbitral tribunal to decide. That was something that was settled and negotiated between the parties. Now then there would have been other arguments maybe to still come to a similar conclusion, but don't unravel the compromise and replace the judgment of the parties with your judgment about fairness. Other thoughts that connect to the judicial decisions would be to calibrate the standards of review in light of democratic considerations. So to to understand standards of review as a mechanism to allocate authority between levels of governance, also in light of the quality of the decisions and the process that led to the decisions in the domestic context. And you have quite a few awards where you can read, that you can read as summaries of principles of good administration, of good governance, also for the domestic context. So to draw to conclusion, I still owe you the answer. Well, in whose name do they decide? And the answer I suggest is that they decide in the name of peoples and citizens. Now that is a high threshold, and it has an apologetic ring to it, I might concede, in the sense that, well, they fall so obviously short of that, and you might say, well, who are they? You just criticize them. There's so many things wrong with the practice, and who are they to claim that they were to speak in the name of peoples and citizens? And might even, I would also concede, have something utopian about it. Could they possibly do that? So I would still suggest that that is the answer. They speak in the name of peoples and citizens, because, well, they exercise public authority that impacts on the possibilities of exercising collective and individual self-determination. And I don't see any good reason to lower the threshold of legitimacy that an act of public authority has to meet, only because it is an act that comes from an international level rather than from a domestic level. And I would also suggest that it is a standard while it demands change. It demands, as it comes with a program for change. And it is one that I would suggest is even more realistic, in the sense that it recognizes that it is implausible and impractical and undesirable. It is implausible and undesirable to try and connect all international public authority and try to tie it back to the input of sovereign states. So that is something that I don't think is either realistic or desirable. And if that's not an avenue, then I think so one needs to think harder about how to divide the authority and how to adjust the international public authority that international investment tribunals exercise. And with that, I would conclude. Thank you very much for your attention. So I look forward to comments and then further questions.
Any comments from anyone? Yeah.
I worry about the secrecy of the development of these have more or less kept out of the public conversation the advantages that they benefit from in the trade pact. What would you say to that?
Yeah, I also worry about that. So at the moment, you have a number of new negotiations going on. What gives me a bit of hope is the fact that not only trade but also investor-state dispute settlement has been a bit pulled out of its niche of a rather secluded, secretive practice, a bit out into the open. So it's a nice thing to see that the debates about the transatlantic trade and investment partnership between the US and the EU now regularly make it onto the front pages of the newspaper. So I think this is where publicness begins. So I think if a topic has reached the front page, or let's say the third page of a newspaper, that's when you can seriously think about or claim that there is something like a public discourse, that it has become subject to public debate. And not without impact. Not without impact. So now the chapter dealing with investor-state dispute settlement in the Transatlantic Trade and Investment Partnership is probably out. It's probably out.
Which is that? Expropriation?
No, that's so the possibility of a direct foreign investor to bring a direct claim against the host state. So Monsanto against the European Union is probably not going to be a possibility. So then there's arguments, maybe that's an overreach, maybe that's too much to throw it out completely. If it's not thrown out completely, the procedure and the law will in any event be a significant step forward and improvement on further older generations of bilateral investment treaties. What concerns, for instance, publicness, issues of secrecy, also the standards of protection. So whereas in the older treaties you had a open definition of what amounts to fair and equitable treatment, for instance, which is one of the standards of protection. Now the standard in the draft that still includes this chapter has a defined list. So to say, well, we accord foreign direct investors fair and equitable treatment, which includes the following, which is a closed list. So you have more control over, arguably, what the adjudicators will do. Now, I want to just add one more thing. I don't think it will do the job as long as the people don't change. So the adjudicators, you have seen developments in treaty language, and also reactions to jurisprudence that have, in a way, evaporated because the adjudicators just continue doing what they've always been doing.
Adjudicators being pro-investor.
Yes. So I would make the claim it's not such an easy claim to make, because if you want to point to decisions which were clearly wrong, it's not so easy, and usually the clearly wrong ones are also not picked up. So you have something like an autocorrective mechanism. So there's some internal critique, and then the really awful decisions are also recognized as really awful, and they don't have precedential value. So there is that. I just don't think that that's enough, because there's still a very deep inbuilt, I would dare to say, bias towards investors. Even if you can't, it's difficult to pinpoint.
Any other questions?
This is a slightly more fundamental question. I thought it was interesting you started with a world with DITs and investment treaties and a world without. So in light of the recent spate and increase in investor disputes we've seen, and the fact that the tribunals are awarding higher and higher compensation, how much do you think it is beneficial for a country to have these investment treaties in the first place? And I know this is a very open question and verdict's been out, but what is your view? Is the long-term cost of the country higher than the actual benefit it's getting?
Yeah, so thanks so much for that question. Because it allows me to connect to what I've just been saying and highlight one of the manifestations of that bias that I was alleging that which exists. Because if you read textbooks in the field, or also awards, it's, in case of doubt, pro-investor. Why? Because it helps the host country. So if you read one of the standard textbooks, and one of the most prominent, prolific people in the field, Professor Schreier, he's written together with Rudolf Dolzer a very nice textbook, and there's a couple of instances in the textbook where they recognize that the jurisprudence is open, so there's debate and choice, and where they make a choice pro-investor. Why? Because increased investment protection helps the host state to attract more investments, which I see as a recognition, testimony or manifestation of the bias. Because then now, I mean, I have not done the empirical research on that issue, and I don't have the means or expertise. That's not what I'm somewhat good at. But I can read those who did it, and from all I understand is it's undecided. From all I understand in a genuine assessment, it's some see a bit, some correlation, others no correlation. From all I understand, it's undecided. Now, if you ask investment lawyers, and that's actually research that I might do, or somebody could do. So, talking to investment lawyers, they are convinced that that is the case. But the basis for that, I would suggest, is lacking. One more thought is that at the moment the interest rates are so low, so the European Central Bank has negative interest rates on capital, that for the first time in history nobody thought that was possible, but so they did it. Let's see for how long. But at the moment, there's capital doesn't know where to go, so they have no place to go. So the consideration of whether or not the host country has signed a BIT, I think, has dwindled in importance even further in light of those developments.
I mean, wouldn't you say that Brazil is a good example for that?
Yes.
And especially like in India, there is an economics-based research which was conducted by the Department of Ministry of Commerce last year, which says that in the Indian context, there has been very little correlation between the investment flows and the signing of the BITs.
Yeah.
So for a country like India, where now with the white industries case there's more awareness and these damages are higher and higher, and we have Brazil in a similar situation. I mean, there's a lot of uproar about India still going ahead and doing more negotiations on BITs.
Yeah, so I said what I understood the state of the debate to be. So there's the Brazil example is part of that debate. There are others withdrawing from the system, and not only Ecuador, Venezuela. Some of whose motives might be manifold and maybe not so much based on the economic assessment of the opportunities, but including Australia. I think was a bit of a relapse at the moment. But, so I mean, so if you think that reality makes sense, then you can refer to those practices and support the argument that maybe they do not have a strong impact on inducing foreign direct investments, but undecided, I believe.
One point is that India doesn't have a BIT with the United States, right? But the US investment is still coming to India. And we do not have BITs with many countries, but investment is anyway coming to the country. So it is not actually a prerequisite. It is an additive in a way. It will give another comfort to the investor. But it doesn't mean that it is a guarantee that investment will come to the country. So that is dramatic.
Probably there's no clause in the investment relationship that entitles the investor in India to receive money if the investment fails. The typical expropriation scene that has been carried on in other places. I would imagine that India would not permit that. That if a local community said that they didn't want this investment happening in their site, in other circumstances, the local community would be required, or the nation would be required, that sign any agreement, would be required to compensate the disappointed foreign investor. But I doubt that that's going on.
So think about the situation where there is, speaking about the Coca-Cola plant in Kerala, in Pachimada. So they had been using the groundwater for carrying out their activities. The local municipal authority, the panchayat, cancelled the license. So literally that is a ban on that particular investment in that state, right?
Right.
In that situation, of course, the decision has been taken on environmental grounds and maybe for legitimate public policy purposes, but the investment has been totally, the value of the investment has been totally nothing action. So maybe a situation where there is a regulatory chill because of the of the policies of the local authority. If there is a BIT, definitely the foreign investor can actually seek compensation. So it actually depends. I think in the case of India, at least there have been a few incidents where governments have cancelled the licenses, but nobody has taken the matter to the authorities. So we have only one case so far, right? But in the foreseeable future, it may be possible.
And they didn't get any recovery.
In the white industries case, definitely they got the damages, but there have been no other cases actually properly settled by the the BITs, by the tribunals in fact. Yeah.
So basically, what my question is related to jurisdiction and more of with respect to the sovereignty, and how much does the sovereignty of a nation come into the picture when the arbitral tribunals are giving an award, especially when such situations are already being decided by the domestic courts. Like you had pointed out the arbitral case, where it had been mentioned that you please go to the domestic court first for the cooling off period, like you had mentioned. So how does the sovereignty of a state actually come into the picture?
Can I ask a follow-up question?
Yeah.
So in a number of BITs, there is actually a fork of the road provision, right? So if the industry is going and filing a case before the local authority or before the local court, they have to basically exhaust the process, and they can't in the meantime take recourse to the international dispute settlement, right?
Right.
So that is actually a case of preserving the sovereignty of the host country,
Yeah.
right?
Right.
And in many, I mean, if you look at some of the BITs, including the BIT, the model BIT that India has actually come up with day before yesterday, right? Mm-hmm. It has actually this mandatory consultation requirement, mm-hmm. and that there cannot be any dispute against India in the 18 months mm-hmm. of seeking the consultation.
Right.
So in a way, it actually preserves the sovereignty of a country, preserves policy space,
yeah.
and could be good for the country. Yeah.
Yeah.
So, but see, again, like if we look at it from another perspective, wherein the domestic courts have already decided over a matter, and then again a treaty claim has been brought up to the investor tribunal. Mm-hmm. So again, that being said, it's actually a flip over from the fork in the road where it says that you go to domestic courts first. Now that the domestic courts have been decided over the matter, the investor tribunal is deciding the matter. So
I'm not sure I understand the last one, but come back on that point if you're not satisfied with what I'm going to say now. So with regard to the notion of sovereignty and jurisdiction, I'm not so sure what the concept or notion of sovereignty adds to the debate that we're having. I think it is a bit of a, I'm not saying that particularly in response to the question, but also in observation of the debate elsewhere, is a bit of a buzzword that lacks content or directive or program. So if it can't be a shield against the exercise of the authority, because it's like to say, well, it's something like will in contract. So the sovereignty of the country would be exercised once you sign a treaty. So there's already a permanent Court of International Justice case, as is Wimbledon, that says that a restriction, so if you sign a treaty, it's not a restriction of your sovereignty, it's an exercise of your sovereignty. So you make a commitment, and then you're exercising you're manifesting your sovereignty by doing that. So it can then not be a shield against the commitments that you have entered into, right? So that's on a preliminary note. Then the debate about fork in the road provisions. Yeah, so such provisions are one tool in the toolkit of possibly giving domestic courts a stronger say, but they are different, of course, from something like a cool-off period or a requirement to exhaust local remedies, because they just give the choice to the investor. So they might still just go to investment arbitration. All they say is, well, you have to choose. Once you do one, you can't do the other. So there's no ordering in favor of the domestic, which a cool-off period might do. But then both for fork in the road as well as cool-off periods, you have seen that on occasion, or maybe even more often than not, they've been rather inconsequential. So one such, actually I would see them as evidence that changes in the treaty language have rather little effect if the people don't change. So Arbitral, clear 18-month cool-off period. What happened? Oh no, you don't need to do it because it would have been unfair, right? Fork in the road has also been watered down. It has. I'm struggling to think of a single case, and I would wonder if there exists one, where a fork in the road position has actually led to a tribunal to decline the exercise of jurisdiction. Usually what happens is that they distinguish the different proceedings. So a domestic court case is oftentimes a contract case. It takes place on the basis of a contract. The parties are different. The International Investment Tribunal case takes place on a treaty claim. Typically, then you might have, even if the contract were incorporated into the treaty, they might still say, well, the basis for the claim here is a treaty claim, different from a contract claim. The fork in the road provision does not preclude us from exercising our jurisdiction.
Right, but that can typically happen in a situation only when there is an umbrella provision, right? So a party may say that actually that party will maintain consistency with the provision throughout the course of the agreement. So if there is no umbrella provision, then it is pretty inconceivable that there could be both a treaty claim and a contractual claim. I agree.
Yeah.
Definitely agree.
Agreed. Yeah. So did you want to follow up? No?
So the only one.
Sorry,
Any other
Maxime?
question?
No, Maxime, you had a question?
Yeah, I just wanted to add something on this question. Actually, what is justifying this regime, since all studies empirically state that there is no correlation between foreign direct investment and EITs, and as I know, these studies are agreed, so there is none. And it's just interesting to see that actually now you can see that as the investment community is searching for a new justification, there's a new narrative emerging, and this is the narrative of good governance and of rule of law. And this is, I think, this, if you will follow up these debates, it will become quite big. I think that since we cannot prove this FDI increase, we have to make this new argument, and the argument goes as follows. There's, for example, Stefan Schill from MPE, who's making it so, for example, fair and equitable treatment, if you look into it, basically it is some kind of rule of law, and you will find many ideas of rule of law embodied in fair and equitable treatment, and the new argument is that, for example, what you also can expect from investment awards is spillover effects. Spillover effects from some kind of international standard of rule of law into domestic regulation, into the domestic or into the domestic sphere. And so this I just wanted to add. So I think it will become more and more important. Maybe a short question. So maybe what do you think about this notion of rule of law in investment arbitration? And yeah, I think that's it.
So, no, it's a very good comment and addition and observation. So, Stefan Schill wasn't only a colleague in Heidelberg, but he also now moved to Amsterdam, actually. So we continue to be tied together and to debate a lot. So, what do I think about this? So I think that it's a very it's a very big, very big question. So one thing is that the critique and the argument would still hold. So everything I think that I've said, I would say in the same way, even under that consideration. I don't think it does a sufficient job in justifying what is going on either, because if that was a concern, there would probably be different mechanisms. You would probably want to give the host country a chance of actually complying. So I'm not so sure. So you might make the argument also in the WTO, and there I might be more sympathetic towards it, because the power or the authority is relatively less. So if you have a ruling against you in your against you, you can comply, and that's the end of the story. Whereas in investment, you don't have the option of complying in a way. You can anticipate what the arbitral tribunal might say eventually, and then shape your domestic regulation in that light or decision making in that light. But that is also something you don't want to do, because that, it's for one thing not so predictable, and you would err on the side of caution maybe, and stop pursuing projects that you might be fully entitled to pursue just because you think you might end up with a significant claim to compensation or damages against you. So it's not a possibility that you can find out and then decide of what you do, like you can in the WTO, because you're stuck with that decision. The last thought on this is one that I'm struggling to break down and to articulate clearly at the moment, which is one that connects to the notion of the rule of law. So there was a nice presentation on the inaugural conference of the International Society of Public Law, ICON, where Jeremy Waldron gave a keynote speech on the rule of law. He comes from a theory of property, which was a PhD and so on, now arguing on the rule of law, where he endorses a conception which I find very plausible of the rule of law that needs to be inclusive in the sense that the person who is being possibly expropriated must be thought of as part of the community, and his property is also only constituted by that same rule of law. So it's a perennial argument about where do property rights come from. Are they something natural, and are they a limit to the rule of law, or are they part and parcel? Are they constituted by that same rule of law? So this is, I'm not, I can't articulate clearly how that connects to that question, but it seems as though that argument buys into a notion of the rule of law where property would be constraining.
Any questions from our LLM students or from the distinguished professors? Yeah.
I'm sorry I didn't hear the presentation, but something I would like to compare is with the International Criminal Court. One of the purposes was that it will exercise a disciplining effect on the domestic jurisdiction. So in other words, it might not prosecute too many, but states joining the tribunal will match that international standard in domestic courts. Basically, instead of facing the danger of having their citizens prosecuted, they will do it domestically. I wonder whether the same disciplining effect is relevant to the international investment trade.
Yeah, so it's, thanks, Westman. So also very interesting. It's, it pushes in a similar direction, right? So that's, so we talked earlier about empirical claims about the effect of the treaties on investment flows. And in a way, this is also a question about causality, and there I'm not so well placed to make a judgment on that, but just from observing the debates that do exist and the literature that exists, which is very profoundly divided. So some suggesting that that might happen. So in the lines that Maxim just said, that it has that effect of inducing good governance, that for sure should not be discriminatory, and so on and so forth. Whereas others say that it replaces and pushes domestic mechanisms, for instance, that would involve the judiciary, as the ICC and the Rome Statute would have an effect. Well, first of all, to put those crimes into domestic criminal codes, and then also have in place an effective judiciary that is willing and able to pursue those crimes. Now, the domestic judiciary is always pushed on the side. So you do not possibly have an effect of a inducing a rule of law that extends beyond maybe something like non-discriminatory administrative proceedings. So it for sure doesn't improve the judiciary at all, because it's not conditional upon the exhaustion of local remedies or so on. So if that was the case, you can say, well, you should do a good job domestically and exhaust local remedies and show that your rule of law loving and practicing state, and then you have nothing to fear from above. But that's not the institutional setup.
Right. In fact, I completely agree with most of your comments. I really agree that there's a huge amount of harmonization happening in this particular field, and this harmonization is actually happening around the polo VCLT.
Mm-hmm.
So it is basically happening Article 31 and 31.3 of the VCLT that talks about any of the rules of international law, right? So although the concept of stare decisis is not actually there in international investment arbitration, by virtue of application of Article 31.1.2 and 31.3.1c, right?
Mm-hmm.
There's a huge amount of systemic integration happening in this particular field. And most of the judges are basically international judges, like George Abissal or maybe Sasudoti, right? So these people are basically adjudicating WTO dispute settlement where there's a huge focus on text. And they also, either argue in cases or they appear as arbitrators in some of the leading cases. So there's a huge amount of harmonization happening at the international level, basically around this polo VCLT. By using the text, and when applying the text, you also apply other principles of international law into this interpretation. So I think there is a huge, if you look at some of the cases, one case is Salin's case. You basically use that particular dispute in order to understand the meaning of the investment in virtually every case. The other dispute is a Mafficini, or you have got the metal class decision. They may be decided by either the UNCITRAL or maybe the ICSID, but all kinds of tribunals are basically using the law, which was basically elaborated and explained by these tribunals. So the one interesting point is that there's a huge amount of integration happening in this particular field, because most of the actors and most of the experts who work in this field are by and large the same. So that is one of the major contributions. We have around 3,000 VATs, but there is a huge amount of harmonization happening virtually in every system. And I feel that this is one of the contributions of this international investment law. And your paper has actually struck the right note. Okay, any further comments? In that particular case, we'll wind up and let me ask, Jindal to give a word of thanks.
Sort of sat through your presentations. I mean, number of in maybe 2-3 occasions I believe, and every time I found it very, very enriching, and I've learned a lot. Although this is not my area of expertise, but I've learned a lot. Thank you very much, James, for your additional comments, as always, exceptional. Thank you very much to my colleagues, Venzke and Professor Marks for joining us, and of course Armin was there as well. And I thank the students who participated. I know it's a very difficult day for those who are actually following the cricket. But nonetheless, you have done us proud. So on that note, I would say thank you again, Ingo. And in case you don't know, Ingo is a visiting honorary professor at the Center for Postgraduate Legal Studies. Ingo came here on the 1st of March. So 1st of March. Ingo did he did a course and a 2-credit course. He taught almost 9 hours a week. He delivered a distinguished public lecture. He traveled with me to Ahmedabad to deliver a special lecture. He traveled to Delhi to deliver a special lecture, and today. So Ingo has been a great learning experience, and we thank you very much for being a part of this endeavor, and it's been a pleasure knowing you. Thank you so much.
Thank you so much.
can we take a photograph with him?
Of course, of
And-
course.